Hi, and welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Vondran Legal Hour. Okay, so we're talking in this podcast slash video, we are talking about criminal copyright infringement. Okay, so, our firm represents a lot of different people and companies, small and large, in copyright infringement actions. And one of the common questions I get is, am I going to jail? Are they going to prosecute me? Let's say you've downloaded illegal movies like Strike 3 or Malibu Media movies, or you are caught pirating software, or you are caught infringing a photography. Those kinds of questions, anything that can be copyrighted can be subject to criminal copyright. So I wanted, a lot of people get worried. They call and they say, well, is there any criminal liability? And I say, well, there's laws on the books. So let's talk about that. And I'm going to give you basically the 4 elements. And this is going to be pulled right from the Department of Justice Criminal Resource Manual. So basically how it works, there's a lot of different organizations and, governmental and private that will investigate, piracy and counterfeiting. And they'll work together, and there's, even international teams working together to, ferret out infringement and find people that are counterfeiting or selling, pirated, false, unauthorized goods. So, but let's go over, we're going to go over and typically the FBI is the one that investigates, the Department of Justice is the one that prosecutes, because copyright law is a federal law. And so that's why you're going to have, that's why the lawsuits are filed in federal court. That's why the Department of Justice is involved. But I'm going to go over the 4 factors that the prosecutors, this is pulled from their own language, that they have to have if they want to try to criminally prosecute someone. And then I'm going to give you just a few case examples, 4 or 5 case examples, to show you the kinds of cases that they have prosecuted in the past. Doesn't mean that it's limited to that. I always tell my clients, you don't want to be the first, do you? We've had, companies that have absolutely, 200 computers with pirated software. So you got to be careful in cases like that. So let's go over the 4 factors for copyright infringement. These are the 4 elements the Department of Justice is going to need to go ahead and prove. Number 1, and this is if they want to bring a prosecution. So remember, in a criminal case, it's different than a civil case. Under copyright law, the civil part of the copyright law, that's if somebody's trying to hold you liable for money damages. That is a strict liability statute. So, and it's preponderance of the evidence. And in criminal law, if you remember watching TV, the government has the burden to prove everything, not by a preponderance of the evidence, but beyond a reasonable doubt. Beyond a reasonable doubt. Now, that is a very, very high standard in the law. It's there to protect that 1% of people that are guilty of something. And I watched a show the other day. It was a drug smuggling show. It was really good. And they talked about, that our drug enforcement is, 99% right. And they showed this guy that had gone to jail for 5 months, and they found out that, well, he was innocent. So beyond a reasonable doubt is there to protect that 1%, that one person. Think about it. If it was you, would you want to spend 5 months in jail, in the name of the system? So it's a really high standard, but let's go over those 4 elements. I've been going on too long now. So, all right. Element number 1, the government has to prove there's a valid copyright, that there's a certificate of registration, that the copyright is valid in that it was not obtained by fraud. And they need to show that it was a registered copyright. That is a prerequisite to bringing the prosecution. And that was the case United States versus Becker, 134 Federal 2nd, 533, if you're looking for that, Second Circuit. So number 1, valid copyright registration. Okay, so that's pretty simple. Yeah, you got to have copyrighted work to have a copyright infringement. Element number 2 Infringement. You have to actually have infringement. Well, that makes sense. To prove criminal copyright infringement, you actually have to have infringement. What is that, though? Let's talk about this. Infringement is anything that violates any of the exclusive rights of a copyright holder. So if you've watched any of my other podcasts and videos, you've heard me talk about the exclusive rights of a copyright holder and why it's so great. You can go register your photo, you can register your software, you can register your video games, your artwork, your illustrations, anything. And when you do that, even if you don't register it, I mean, copyright is inherent the moment you fix your creative expression into a tangible form. But at any rate, you get the bundle of rights. Now that's nice, so for 40, 50 bucks, you file a copyright, you get this bundle of rights. And if anybody violates any of your rights, then you have a case, at least in a civil court, and possibly the government would pursue it in a criminal court. So what are those rights? Those exclusive rights include the right to display or perform the work publicly, so display or perform publicly, and the right to reproduce and distribute copyright works and to make derivative works, turn your book into a movie and things like that. So any unauthorized exercise of these rights will constitute an act of infringement and will give rise to at least a civil infringement claim by the copyright holder. So again, we're quoting you right out of the justice.gov criminal resource manual, and that's what it says. So number 2 element is you need infringement, a violation of one of the exclusive rights of the copyright holder. And infringement also requires proving some sort of copying, that there had to be some sort of, it's copyright, so we need some kind of copying. Although the manual notes that this can be difficult to prove, and that's why courts will allow evidence of access and substantial similarity. So showing that you had access to the copyrighted work and that your copy that you made is substantially similar. So that's the copying. And there's special rules on software, computer programs. I just want to read this to you because there's a lot of software claims that are brought. With regard to infringement of copyrighted computer programs, a court must also determine whether or not the copies at issue were lawfully made. This determination is necessary because 17 U.S.C., that's United States Code, Section 117, allows certain copies to be legally made, like backup copies. Thus, unlike copies of other types of copyrighted works, copies of computer programs are not automatically presumed to be unauthorized. Okay, so part of the infringement test is to make sure that, it's not something that's legally protected. And finally, they talk about, in regards to the second element of infringement, the concept of statutory exceptions. The 2 main ones being the fair use doctrine, although they note that this could be very limited in the criminal context, very relevant in the civil context. We have lots of videos out on fair use if you want to go check that out. And also the First-Sale Doctrine. Now, the First-Sale Doctrine, essentially in a nutshell, means if you buy something, if you go to the store and you buy a book, you get title to the book and you have a legal right to go and resell that, okay? So that would be authorized. Now, where it gets tricky, and this is in software, nowadays you don't really buy software anymore, or, many times you never did buy software. What you got was a license. So you never really got title, it's like you get title to a car when everything's paid off. But the First-Sale Doctrine says, well, you don't actually have title, so you don't actually have the right to another sale. So that gets really tricky. That was the Werner versus Autodesk case. I've got a blog on that if you want to check that out. It's good stuff. So second element is infringement, making sure there's no defenses, make sure there's copying. Okay, so we're moving along here. You got the gist of this. Number 1 is existence of a valid copyright. 2 is an infringement, copying, no defenses. Element 3, the government has to prove some type of willfulness, criminal intent. Sometimes we call it the scienter. In law, we call it the scienter, that guilty mind. The mens rea is also what we refer to it as. And The criminal intent, there's a split, as this manual notes, there's a split of authority. Now, I do a lot of law in the Ninth Circuit, that's California, Arizona, also covers states like Washington and Idaho, Montana, Utah. And so in the Ninth Circuit, the willfulness means the intent, but only the intent to copy. So in other words, you pull out your copying machine, you put your disk in there, you were intending to copy, that's good enough. But in a majority of jurisdictions, they want the prosecutor to show, beyond a reasonable doubt, the intent to infringe, the intent to actually consciously be aware that you're infringing on somebody's copyright. So this is where it gets interesting, and this requires a prosecutor to show that there was actually a violation of a known legal duty, that you consciously knew you had a duty not to violate one of these exclusive rights. And this is where, ignorance of the law, usually that's not a defense, as most people know. In this criminal aspect, in a majority of jurisdictions, if it's shown that you didn't know you were actually infringing, that may get you off the hook. So that's a real interesting little wrinkle that I didn't even know. I got this out of the manual, and I was like, wow, okay, that's pretty interesting. So there's a split of authority. Those are the kinds of cases someday that goes up to the Supreme Court of the United States, and they decide what the law is. But you never know if that's going to happen or not. So even if you have ignorance of the law, again, keep in mind this is a strict liability tort. You can still be sued in civil court for copyright infringement, even though it's quote-unquote innocent. And we have plenty of other videos and blogs, so I'm not going to go on that. So element 3 is that criminal intent, that willfulness, and that can depend on what jurisdiction you're in. So those are our first 3 elements. The final and 4th element, the government must prove, anybody guess? They must prove commercial advantage or private financial gain. Okay, so all this copying and infringement, and whether you knew it or not, all that stuff doesn't mean anything unless they can prove that you were doing it for private financial gain, or you had a financial purpose. Okay, so if you're doing something exclusively, you're infringing something just for your own use, your personal private use, you may be able to fly under the radar, as they say. And so I'll just read this to you. In addition to demonstrating willfulness, the government must prove that the defendant engaged in an act of infringement for purposes of commercial advantage or private financial gain. That's 17 U.S.C. 506A as in apple. Emphasis should be placed on the word purpose because it is not necessary to prove that any profit was realized. That's United States versus Taxi. The drafting committee's purpose in retaining this requirement has been to exclude from criminal liabilities those individuals who willfully infringe copyrights solely for their own personal use. Okay, so evidence of discrete monetary transactions. But it also says here that it is a common misconception that if infringers fail to charge subscribers a monetary fee for infringing copies, they cannot be held to have engaged in criminal copyright infringement. So as they say, private financial gain does not require the payment in money. Trading anything of value or bartering is just as liable. Okay, so there you have your 4 elements. You have number 1, your existence of a valid copyright, registered copyright. 2, you have the infringement, the copying, the violating of an exclusive right. Number 3, you have the willfulness, the scienter, the criminal intent. And 4, there needs to be some commercial advantage, purpose, or some private financial gain. Okay, so those are your 4 elements right there. And I'm going to go over just a couple other things here. I got a page here on penalties. I'm going to be real quick on this. I'm not even going to talk about this much. You can look it up if you want. This is 17 U.S.C. 506A and 18 U.S.C. 2319. And generally, you can be looking at 1 or more copyrighted works with a retail value of more than $2,500 can be imprisoned for up to 5 years and fined up to $250,000 or both. If you're a repeat convictor, repeat offender, I should say, 10 years, 250,000 fine or both. So, I mean, you obviously don't want to be engaged in this stuff. Now, let's go over just a couple cases here, and I'll try to make this short for you. I know you're all busy. But a couple of cases where the prosecutor, the government, proved the guilt and got the guilty plea or got the settlement or plea bargain, as we say. All right, number one, we have a Houston man. This is out of the Eastern District of Virginia. Houston man who basically was found out by the National Intellectual Property Rights Coordination Center, say that fast. He was convicted on one count. Actually, he pled guilty to a criminal information, one count of criminal copyright infringement, maximum penalty of 5 years. I just mentioned that, and he had to forfeit over $28,000. In a sentence, he was, put it to you shortly, he was selling he was selling pirated copyrighted software, including Microsoft, Adobe Systems, Intuit, and Semantic. Looks like for a period of about 3.5, 4 years. He received at least $154,000 in proceeds. And the IPR Center in Washington is one of the U.S. government's key weapons in the fight against criminal counterfeiting and piracy. They were involved on that. If you want more information on that, there's an iprcenter.gov. So, number one, selling pirated software online, never a good idea. That's something that will catch the eye of a prosecutor. And you get these, like, let's face it, you're dealing with these gigantic software companies, Microsoft, Adobe, they're not just going to look the other way if you're selling their stuff online without authorization and they're, pirated copies. Okay, so that's one thing that will raise eyebrows. Here's another one selling copyrighted software. This is a internet seller of pirated software sentenced to 18 months in prison for criminal copyright infringement. 18 months. This was a man out of Syracuse, New York. He had sold more than $250,000 worth of pirated software. He was ordered to pay $272,655 in restitution to the copyright owner and sentenced to 3 years of supervised release following his prison term. So again, no fun. He pled guilty to a single count of criminal copyright infringement for manufacturing and distributing. Remember I said one of the rights were distributing pirated copies of popular business engineering and graphic design copies of Adobe, Autodesk, another giant company that we deal with, Intuit, Quark, and others over more than a 3-year period. According to the court documents, he operated under the business name Software Suite, so they can sound real fancy and official. They sold on various websites, including buysellcommunity.com, adpost.com, and I couldn't believe this. They got a great domain. If nothing else, this domain would probably pay the restitution in the sale of the domain, www.sell.com, S-E-L-L, not C-E-L-L, if you're trying to be funny there. No pun intended, of course. At any rate, many of the customers would pay by PayPal, and then he would mail pirated copies that he had burned to CD or DVDs. So again, you're manufacturing, you're copying, you're making these rogue copies, and he received at least $270,000 in profits. So again, they don't like this. Big problem with copyrighted. And, these things can ruin your life as far as, licensing. You may never be able to get any type of license, real estate license, broker's license, stockbroker license, if you have these convictions. So, you got to think about this before you do it. Next case I have comes from Delaware. This is digital theft, massive selling of pirated software online. Again, you see the common theme here. FBI made undercover purchases of over 20 software titles from various websites like cheapestsoftwareanywhere.com. That's a long one. cheapestlegalsoftware.com, and was selling products like Adobe, Apple, Autodesk, Microsoft. Again, professional-looking websites, FBI executed search warrants, so forth and so on. And the person admitted, this was actually a female from Newark, Delaware, She was sentenced to 58 months in prison because she admitted selling over 400 software titles on her website, and she had been earning approximately 25 to 35,000 per month. So, what's that? 300,000-400,000 a year from her sales in the past 2 years. So again, these things are going to catch an eye. Worst thing you can do. Then we have some more interesting cases here. I'm going to give you three more. This was a case, so I call it the fake torrent scheme. This was attorneys going down here. And this was out of the District of Minnesota. You had these two attorneys that had created what they called a multi-million-dollar scheme to fraudulently obtain payments to settle sham copyright infringement lawsuits by lying to state and federal courts throughout the country. They were charged with conspiracy to commit mail fraud and wire fraud, money laundering, as is noted in this press release, abusing their positions of trust as attorneys and exploiting our justice system. So what happened here is these two attorneys had basically obtained more than $6 million by threatening copyright lawsuits against individuals who supposedly downloaded their pornographic movies from file-sharing websites. Okay, so, our firm handles these file-sharing websites where you have companies like Malibu Media, Prolific Filer, Strike 3 Holdings, a prolific filer of adult torrent sharing their pornographic films on the internet. So you have a lot of this going on. These entities, these individuals, I should say, who I'm not going to name, created a series of sham entities to obtain copyrights to pornographic movies, some of which they filmed themselves, and then they uploaded those movies to file-sharing websites like the Pirate Bay. That's the one I keep telling everyone, tell your kids to stay off the Pirate Bay. It's fun to download, but you could get into big trouble and end up paying a lot of money and harm your future. So in order to lure people to download their movies, they filed bogus copyright claims, infringement claims, concealing both their role in distributing the movies and their personal stake in the outcome. So they weren't candid with the court, okay? So they weren't telling the courts that they had actually set up the scheme, okay? These attorneys then used extortionate tactics such as letters and phone calls, threatening victims with enormous financial penalties and public embarrassment. That's why we call them shame settlements, unless they agreed to pay a $3,000 settlement fee. So at the end of the day, they had collected $6 million from fraudulent copyrighted lawsuits. At some point, the courts caught on. And they started what they're calling they tried to facilitate a phony hacking lawsuit. They started to claim, the defendants changed their tactics and began filing lawsuits falsely alleging that computer systems belonging to their sham clients had been hacked. So, there was all kinds of stuff going on, ruse defendants, as they called them. So that's another bad one, engaging in that shady conduct and doing those kinds of things. So that was another prosecution that the DOJ went after. Here's the next one, online piracy schemes. This is what they called the software piracy crackdown Operation Fastlink. They obtained, this was from 2009, so I don't know if this is still ongoing or not, but they obtained their 60th felony conviction. This was a multinational software piracy organization. They were targeted as part of the Operation Fastlink, an internationally coordinated 18-month investigation. So that may not be going on any longer, but I would assume there's probably something else going on. But what do I know? I'm just an attorney. The guy was sentenced. He faced up to 5 years in prison, a $250,000 fine, and 3 years of supervised release. Those are the penalties we talked about. And the defendant admitted for nearly 4 years he was a participant in this Juarez scene, an underground online community made up of individuals and organized groups who engage in the large-scale reproduction, modification, and distribution of copyrighted software through the internet. In the Juarez scene, this person served as the person who would obtain the new video game releases, so this involves video games, and circumvented the digital copyright protection, so we know that's a DMCA violation, what they call the anti-circumvention protections, so that the software could then be reproduced and distributed on the internet. So again, busting open their code, figuring it out, reproducing it, selling it, that kind of stuff just does not float. It will catch the eye, as you can see, a lot of common themes in the types of cases that are brought here. Operation Fastlink involved more than 120 search warrants executed in 12 countries. So hundreds of computers were involved in the removal of more than $50 million worth of illegally copyrighted software, games, movies, and music from illicit distribution channels. Okay, so those are what we're talking about. I think you're catching the theme here. I got one left. And I have another set of cases that I'm going to do that are slightly different, but this one was interesting. It'll be my last one in this episode. But a man was sentenced. This is in the Eastern District of Louisiana. Again, this is massive infringement, and this highlights why you don't do it when you're in dealing with movie companies or the music companies, like the MPAA, Motion Picture Association of America, or the RIAA, the Recording Industry Association of America. These are behemoths, okay? They don't take infringement lightly, it's a very tightly controlled. So in this case, you had somebody that was sentenced to 4 years probation, 8 months in home confinement, was fined $1,000, ordered to pay restitution in the amount of $12,539 to the MPAA and the RIAA. What did he do? He used a digital camcorder to record approximately 10 first-run motion pictures at the AMC Theater, West Bank Palace, located in Harvey, including When the Game Stands Tall and The Equalizer. He then subsequently duplicated and sold copies of some or all of the motion pictures. He manufactured and sold CDs and DVDs containing copyrighted musical works and motion pictures out from his business located in Harvey. Specifically, during the execution of search warrants, blah, 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 they seized approximately 2,932 pirated DVDs. That's quite a few, folks. Quite a few DVDs. It sounded like he got a pretty good deal there, all things considered, including copyrighted musical works, including Kingdom Come by Jay-Z and Dangerously in Love by Beyonce. Criminal counterfeiters are economic parasites, they say, who harm legitimate businesses that pay taxes, create jobs, and support our national economy. Okay? Involved in this looked like you had immigration and customs enforcement, homeland security, so you can see all the different entities getting involved. So that's about it. So you get a flavor of what these are. I have here statute of limitations. I'm going to do a separate one on that, but there can be different statute of limitations from 5 years of the date of the crime. I'm going to do a separate one on that so I don't overload you on this video here. And protection of copyrighted notices, if you're screwing around and falsely placing a false notice of copyright on an article or publicly distributing articles which bear a false copyright notice, and importing for public distribution, any of these with fraudulent intent violate 17 U.S.C. 506. So I'm going to stop right there. I'll do separate videos on those probably warrant a separate discussion. But that's it. I wanted you just to have a feeling. So many times in our copyright infringement cases that we handle, many times we don't deal with these kinds of things that are going to, grab the eye of a prosecutor. But you have to be aware the laws are on the books. You don't want to be the poster child for the next federal criminal indictment. And this video hopefully has shed some light on that topic for you if you're worried about these types of issues. If you're worried about these issues, I can tell you, you should definitely lawyer up, call a lawyer, make sure you know what's going on. And we've helped many companies in a wide variety of infringement cases settle their cases and get through it without going to jail, so to speak. So at any rate, this is general legal information only and not legal advice. If you liked the podcast or video, give us a like. Feel free to share this on your social media networks. We're trying to educate as many people as we can. As always, our motto is to make the law more understandable and accessible, okay? Make the courts more accessible. Attorney Steve out. I got to run. If you need more information, you can find me on the web at attorneysteve.com. That's attorneysteve.com. Thanks a lot.